Good morning. This is Attorney Vince Davis, and these are my office hours today. First thing we're going to talk about this morning, there is going to be, looks like, a record settlement for victims of abuse. Specifically, I think it's sexual abuse here in Los Angeles County. It's been announced that there is approximately, I think, going to be a settlement of about $4 billion. That's billion with a B, here in Los Angeles County to victims going back all the way to 1959. And there are a number of victims, I think there are thousands of victims represented by various attorneys and law firms. And how they're going to allocate the settlement to different victims, some getting up to seven figures, some getting, six figures and on down the line. And it's even been said that some of them may get nothing, which is kind of surprising, but, that's up to them and their attorneys. But if you were a victim of sexual abuse while in the custody of LA County in the different facilities, both probation facilities and DCFS facilities, such as McLaren Hall, you should be contacting or Googling a lawyer to help you in this matter, because there's going to be a huge huge settlement paid out to these victims. I actually know one of the victims who is involved in this lawsuit, and he actually came to me to represent him in another matter, not in this lawsuit. He already has a lawyer, fine attorneys who are representing him, and he is what is called a tier one victim, meaning top of the level victim, meaning he was substantially abused, sexually abused, while he was a foster child at McLaren Hall in Los Angeles County, probably in the 80s or 90s. Most of the tier one, from what I understand, tier one victims are from the 80s, 90s, and early 2000s, when a facility known as McLaren Hall was opened. McLaren Hall, when I first started doing CPS cases where children were housed, because foster families, that wasn't a big thing back then, or they couldn't find a foster family to put you in. They put you at McLaren Hall. It's similar to the Orange County facility that they still have, called Orangewood. And these types of facilities, at least in the past, were known to be notorious for kids to be placed there and then be abused. A lot of the abuse happened allegedly while the children were being drugged and abused by other children and by staff members, allegedly. So if you, and I've talked to attorneys about this, and I guess the next step after this case is settled is a lot of these attorneys are going on to other counties, other states, and other counties, and finding the victims and pursuing legal action in those geographic areas. So if you know of anyone, or you yourself were a victim of sexual abuse while you were in foster care as a minor, you should be looking for an attorney, or contact me at the number on the screen, 888-888-6582, and we can help you or help you find a lawyer to protect your legal rights. All righty. I already have a comment. It says, "Hello, I need help. I am worried I won't live long anymore. Please help. I am from South Africa." And her name is Lika. Lika, I have a telephone number right there on the screen. You can call there 24/7, leave a message, and I'll get back to you. All right. In the past few days during the office hours, We've spoken about the detention hearing, we've spoken about the adjudication and disposition hearing, and we've spoken about the 6-month review hearings. Today, I'm going to talk about the selection and implementation hearing. It is the hearing that's known as the 2-6 hearing, the 366.26 hearing. It is called the death penalty of the juvenile court system. It's where you could go and lose your parental rights to the child. And the child can be adopted, and you could possibly never see the child again until the child is an adult. So yes, they actually terminate your parental rights, and someone else adopts your child. A lot of times, foster parents who are not related to your family end up adopting the child, and you lose all of your rights. The first place to start preparing for a 2-6 hearing is at the hearing before that, which is 120 days prior. At the hearing where you lose your family reunification services, at that hearing, you and your attorney should request what's called a bonding study. And that request, depending on the judge, can be made orally or it might have to be made in writing. The biggest defense to the termination of your parental rights at the 2-6 hearing is to prove that there is a relationship between you and the child such that it would be a detriment to the child, not to you, but a detriment to the child to have the parental rights terminated. Okay. I don't know if you've had a 2-6 hearing or heading to a 2-6 hearing, but here's one of the things that happens. It's very subtle, and a lot of people don't understand why this happens. From the date that you lose your family reunification services to the date of the 2-6 hearing, a phenomenon happens, and there's a reason for this happening. The social worker requests the judge to reduce your visitation. Now, I don't see any reason to reduce your visitation except for one, and that is so whatever bond that you have with the child is lessened, thus making it harder for you at the 2-6 hearing to prove that there is a bond between you and the child, a bond that would be detrimental to break. So they use that 120 days to basically break your bond that you probably have with your child so that it's lessened or non-existent at the time of the 2-6 hearing. So it's important at the hearing where you had a termination of your family reunification services to argue and to put on evidence that visitation should not be lessened, should not be decreased. I have come across counties where they actually ask the judge at the termination hearing to decrease the visitation, not the termination hearing, the termination of family reunification services, to order a decrease in your visitation. And in some counties, some judges will do it and some judges won't. And CPS is very smart about this. They ask the judges to do it when they know the judge will do it. They've already felt the judge out over, hundreds of cases. So you and your attorney should be prepared to fight. Then in cases where the judge is likely not to do it, they don't ask. Instead, 2 or 3 weeks after your family reunification services are terminated, they just on their own decide, as the social worker on the case, oh, we are going to decrease your visitation from 2 times a week to once a month. Now, if you go from visiting your child 2 times a week to once a month, guess what? By definition, by scientific and sociological facts, your bond between your child is going to decrease. That's just the way, relationships between people work. And when you get to the 2-6 hearing, you're not going to be able to prove a bond that's so strong that your rights shouldn't be terminated. So this is something you have to focus on right when your family reunification services are decreased. So first, right when your family reunification services are terminated. So the first thing you have to focus on is not getting your visits decreased. If the judge orders it or the request is made, you and your attorney have to be prepared to argue or present evidence to not let your visitations be decreased. You will know whether they want to do it because in the report that they file prior to the hearing where they terminate your family reunification services, one of the recommendations will be to decrease your visitation. So you're on notice and your attorney is on notice that that's one of the things that they'll be requesting. So you and your attorney have to be prepared to present evidence that that shouldn't be allowed. Whether your your visitation is decreased or not decreased, your attorney and you should be prepared to make an oral motion and then later a written motion for a bonding study. Now, what is a bonding study? A bonding study is where typically a psychologist evaluates you and the child to determine how strong the bond is, to determine whether the bond is so strong that it would be detrimental to terminate the parental rights. And you want to do that early on as possible. Why? Because early on, you have that strong bond, and there's not a move to decrease your visitation. I hope you follow that. I'm going to say it again. You want to do it early on because there hasn't been a move to decrease your visitation. Remember, when your visitation is decreased, your bond starts to go down, it starts to disappear. So you want to make that evaluation upfront, early as possible. Once you make that get that bonding study granted, you want to make sure that you and your attorney try to pick someone that is more family oriented rather than CPS oriented. Okay. Yes, there are therapists out there, that tend to be family oriented and those that tend to be CPS oriented. It's just like, there are people out there that are Republicans. There are people out there that are Democrats, right? There are people out there that on either side of every aisle on every issue in life, including these types of issues with respect to whether your rights should be terminated or not. So those are things that you should consider. You can get recommendations from a lot of attorneys, especially private attorneys, who pick out therapists who may be pro-family. I've had bonding studies done in many cases. In a lot of cases, the bonding study comes back. Yeah, Mr. Davis, there is a bond between the parent and the child such that termination would be detrimental to the child. But I've also had it come back the other way. And to make matters worse, I'm thinking one particular case in Orange County where the bonding study came back pro-parent, it would be detrimental to terminate the parental rights, blah, blah, blah. We present the evidence, the expert testifies pristinely, and then the judge in making the decision says, I don't find the bonding expert credible. Like, what? And the expert has, been doing this 30 years and has all the right credentials and blah, 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 blah. And the judge found that the bonding expert was not credible and didn't follow the recommendation not to terminate the parental rights and went ahead and terminated the parental rights. And then on appeal, I thought I was the smart guy and appealed it. And of course, the Court of Appeals agreed with the judge, and I lost. I have to say that that case was, there were a lot of things going on in that case that made it, a bad case. There's this old saying in the law, bad facts make bad law. And that was a case that had a lot of bad facts. So, but I digress. Bonding study. That's the first thing that you should do. The second thing that you should do is you should start planning on working on your reunification services. Now, I already said that your reunification services were terminated. Well, when they're terminated, you and your attorney are going to have to figure out a system, sometimes coming out of pocket yourself, where you can get or do family reunifications. You should continue or complete your parenting, your drug counseling, your drug testing, your anger management, your domestic violence, your individual counseling, no matter what it was. And you should continue that, because maybe, during that 120-day period, you have completed enough where maybe at the 60-day period or timeline, you and your attorney can file a 388. Now, I think every state has something akin to a 388 petition. And I've said before, a 388 is a very powerful mechanism. It's a get out of jail free card. It can change any order made in the CPS case. For example, it can change the termination of your family reunification services. It can give you back family reunification services. It can go from having your children in foster care to giving the children back to you, or giving you unmonitored and overnight visits. So it's a very powerful tool. And if you lose the 388, you can always appeal that as well. Have I ever seen this strategy work? Yes, I have. Many occasions. The odds are still against you, but it is a strategy that I have seen work on many occasions over the decades. So that is something that you should be speaking to your attorney about. If you need more information about that, please feel free to give me a call. So we have the bonding study, we have the 388. The other thing is, you have to make sure that your child is placed with a friendly relative or family friend. Now, if you've waited this late in the game to try to move the child to a family friend, a family member, or a friend, it may be too late. Not impossible, because what the social worker is going to allege is that there is a bond between the foster parent and the child, such that moving the child would be detrimental. Hell, a woman called me the other day and told me, "Oh, I'm 4 months into the child being in foster care, and I've come up with some relatives who want the child." And the social worker said no. And the reason why the social worker said no is because the social worker said there's already an emotional and physical and psychological bond between the child and the foster parent. And I'm like, what? I mean, that might be true. People and babies are like that, but that's not what the law says. And I told the person, you got to go file a motion or a petition to have the child placed with the relative. Same thing during this 120-day period. You have to file and have to try to move the child to the relative or to the family friend. Now, a few years ago, the Court of Appeals in California came out with a case that said even if the child has been with the foster parent all of this time, the court and the social worker still have to consider placing the child with a relative, because that's the law, that's the mandate of the state and federal law, placing the child with relatives. That theme is what makes all of this constitutional, preserving the family. And a lot of people forget that theme of the juvenile dependency system. Families first. Preserving the family is a constitutional mandate. So just because kids are placed in foster homes doesn't mean that that's where they should be, legally speaking. So always make that motion, always find those relatives. On Monday, tomorrow, I'm doing a case, making the first appearance. And one of the things I try to do on every case is I tell my client to give me a list of 25 relatives and friends, um, where the children can be placed right from the beginning. This isn't 6 months into the case. This isn't 18 months into the case. It's right at the beginning. It's hard. It's easy for a social worker to say, I don't like grandma, so we're not going to place the child there. But it's hard for a social worker to say, I don't like 25 people on this list. I mean, you can say no to one, but it's hard to say no to 25 people. All right. And if I represent one parent and somebody else represents the other parent, and they come up with a list of 25, that's 50 people. How in the world is a social worker going to say no to 50 people? I mean, that's almost impossible. And, what makes it even better if some of those people live outside the county, some of those people live outside the state, and some of those people can live outside of the country. Yes, they can. I have a case right now where I'm trying to get children released to relatives in Italy. Unfortunately, the Italian social workers went out and did a report on the relatives in Italy, and apparently the relatives, the grandmother was in favor of taking the kids, but the grandfather wasn't in favor of taking the kids. So we got kind of a negative report on that. But I say that to say these relatives can live anywhere in the world. So if they're in Italy, shoot for it. Okay. There's an interstate, there's a law, the interstate compact, which means placing the children in a different state. There's the intrastate compact, placing the children in the same state but in a different county. And there's an international compact, international treaty, federal law called the Hague Convention, and that's placing children in other countries that are part of the Hague Treaty. Not every country is part of the Hague, but I had a case a few years ago where children were placed in Switzerland. And California being so close to Mexico, I've had several cases over the years where children were placed in Mexico under, in Mexico they call CPS DIF. I forget what it stands for, domestic something familia, something like that. And children are placed in Mexico with relatives, not foster parents who want to adopt and keep the children from you, but to keep the children within the family. So that's one of the other things that you have to consider. You have to consider making that motion to place the children with friendly relatives, so that hopefully in the future, if your rights are terminated, you might somehow reunite. And I use the word and I stress the word friendly because there's always that relative, that third cousin who you don't know, who hates you because the social worker has turned that person against you. And you'll never see the children. Never see the children again. I have a case right now where the children are placed with the mother's first cousin who could never have children. And that first cousin, for whatever reason, has jumped on the social worker bandwagon and doesn't let the children see, talk to, or associate with the biological parents at all. And it's kind of interesting because it's alleged that before she adopted the children were placed with her in foster care, and she did a lot of travel. And whenever she traveled, she allegedly had the parents come over and babysit the children for like a weekend or a week, and the social worker never knew about it. My client has provided me pictures and videos that they took while they were babysitting, the kids while the caretaker relative was off traveling. But we're going to see what happens in that case. Okay, so we've talked about the different ways that you can defend against the termination of your parental rights. If you have any other questions and are facing or coming up facing a 366.26, aka a 2-6 hearing to terminate your parental rights, give me a call, 888-888-6582, and maybe we can talk about it privately. There were a couple questions in the comments, and when I don't have a co-host, it's hard to keep up with the questions. Joseph Rogers on YouTube says, we didn't let them reduce our visitation. They let us have more unsupervised, thinking we'd take our daughter back. Then they'd zap us with abduction charges. We took our daughter to the courthouse. I tried to use that reverse psychology on you there, Joseph. Pebbles Mullane on Facebook says, hi, can you help me? I really miss my kids. Pebbles, give me a call, 888-888-6582. Lika, I think I saw somewhere you're in South Africa. Lika, you can phone now. We have receptionists 24/7. 888-888-6582. If it's an international call, I can't tell you how to make an international call from South Africa to California. You might have to Google that. Let's see. Okay, I can't find any other questions. A lot of comments. It's always interesting reading the comments. Oh, here's something interesting because this comes up a lot. Joseph on YouTube says there are only two families in the world. My old grandmother used to say, the haves and the have-nots. Cervantes. Yeah, Joseph, I'd have to agree with you. But if you're one of those quote unquote have-nots, there are a lot of things that you can do. A lot of things you can do. Okay, I think we have NYP on YouTube. Looks like NYP is a channel member. She asked, or he asked, are you allowed to talk private with the judge? Unfortunately, NYP, that's not allowed. I don't in California, and I don't think it's allowed in any state. You'd have to talk to your lawyer, but I don't think that's allowed anywhere in this country. DeWitt Swales on YouTube says, I've called and been told someone will call me back, and no one has. Went through Bob Pace as well and have heard nothing. Okay, DeWitt, this is what you do. You get out a pen and piece of paper, and I hope you are ready. I'm going to give you a phone number to text. It's my personal mobile phone number. Okay? Text me at 310-308-7758. 310-308-7758. Text me your name and number, and we can communicate that way. And I guarantee you, I will contact you today. All right? NY from YouTube says, how can you change the judge? Well, NY, it depends on what state you are. I can tell you in California the ways that you can change a judge. Number one, right at the beginning, you have an automatic right to change a judge within a certain time frame, and you follow it. You do that by filing what's called a 170.6 affidavit. After that time period, you can change judges by filing certain types of motions. They call them 170. There's a family of sections called the 170 motions, where basically you can change a judge if you can prove that the judge has been prejudiced or biased against you in some fashion, usually by the judge's actions or words, mainly words, that you can change a judge. I've seen it happen in the past. It's not something that comes up all the time because judges, don't make these mistakes usually. You can't prove usually what's in a judge's mind, but if a judge says something, on the record or in front of people, obviously you can make that type of motion. I can tell you that in California, and I think in a lot of states now, people making complaints to the Judicial Council are being taken seriously these days. Not too long ago, maybe it's been a year or two, maybe even longer than that, I was contacted by an investigator investigating a complaint against a judge. It wasn't me or my client who made the complaint, but I happened to be an attorney who appeared in front of this judge on a similar type on a CPS case. And the investigator was really asking some difficult questions to me about this judge, um, and whether I thought this judge was fair or unfair. Um, so, I mean, and I wasn't even the attorney for the party making the complaint against the judge. It's just that they had combed through the records and found out that I had appeared a few times in front of the judge, and they wanted to know, did I think the judge was biased? Did I think the judge was unfair? Did I think the judge was rude? Those types of questions. And after the interview, I was kind of surprised that they had such serious types of investigations about about a parent's complaint about a judge. I mean, I was very surprised. In this particular case, I can tell you that I didn't have anything negative to say about the judge. And I thought the investigator was really looking for me to say something negative about the judge. I said, I can't tell you what happened with this particular parent making the complaint. I wasn't in the courtroom, but whenever I appeared in front of the judge, um, you know, I didn't have any complaints. I did say this particular judge, was tough on my client. But as far as being unfair, I couldn't say that as a professional, um, as a lawyer appearing in front of him or her. But I really thought that the investigator was looking for something for me to say to use against this judge, and I found that surprising. I don't know if it was a good thing or a bad thing, but I was surprised. All right, we're past the end of the show. Listen, if you have any other questions, email me or call me at 888-888-6582. My email address is v.davis@vincentwdavis.com. And I want to thank you all for watching. And I will see you all tomorrow at 6:30 a.m. for office hours. Have a good Sunday, everyone. Take care and be safe.